And we are live. Okay, hello, and welcome to Fermenting Opinions, another YouTube Live, Google Plus Hangout type situation. I'm your host, David Papiden. James McVeigh is not here. YouTube Live. Oh, wow, I've got some kind of situation, double thing going on here. I'm sorry. I'm your host, David Papiden. James McVeigh. Okay, let's bring that back. Okay. So I'm getting kind of like double feedback kind of situation. I think I had like a YouTube page up, so I was like hearing myself a second after. It's not really entertaining or anything anybody wants to hear.
I actually heard it.
Did you hear it as well?
Yeah, it was cool. It was like futuristic.
Yeah,
like our guest.
Myself into the future. Yeah, that's good. I had it up just to make sure all the things on YouTube. I'm not a tech genius, by the way. I'm a person with opinions on things work. So I apologize for that, as always, for whatever technical issues we're having. But I am joined tonight by Lace and by Tim, who is a member of our Facebook group, Fermenting Opinions. He is joining us all the way from Japan. Which is why we're why we're coming on in a later hour, because we're actually on his lunch break. This is like 9:45 in the evening for us, and it's like 11:30, 11:45 the next day. This is his lunch break. He's taking the time to join us, so we really appreciate it. Tim, you said you're a JAG? Is that correct?
Yeah, so I'm an attorney in the Marine Corps, so I'll just start off by saying that all these opinions that I would give are my personal opinion, don't reflect the Department of Defense at all. I have to say that. But yeah, I'm working out here in Japan, doing various legal to non-legal work. But yeah, I'm really glad that y'all invited me, and hopefully I can provide some interesting context or opinions in this conversation. So
yeah, absolutely, and we really appreciate having you. Yeah, and again, I understand being sort of militarily affiliated, and you're not supposed to speak out directly against the president or the administration or anything, or the government or anything like that. We're not asking you to do so. We're just sort of looking for some some bounce back on opinions, because
yeah, absolutely,
a lot of opinions. I'm not a lawyer. I do sometimes stay at a Holiday Inn, but I'm not a lawyer. And so yeah, let's just talk about things that are going on right now. I posted in sort of the the opening byline type thing that tonight the main topics at hand are, we're going to talk about the Trinity Lutheran versus Comer SCOTUS decision that came out, I believe it was yesterday, and also about what's going on with the Trump Muslim ban, and what the Supreme Court is also saying about that, and what's going to be going on with that in terms of developments, and what and in both cases, what are the constitutional issues at hand?
I'll
go for it.
No, I was gonna say I guess we'll just agree to call it the Muslim ban.
Yeah, I mean that's the thing is like
No, that's I'm just.
No, that's fine. Yeah.
Cut in on something.
Go ahead.
So it's interesting he says that, because I was just hanging out with my little brother, who is really cool, and he's very much he's called himself a libertarian, but he's Christian and right-leaning. And he said the same thing the other night, because I called it a Muslim ban, and he goes, "Oh, you're just going to use like popular phrases?" And I'm like, "Really? Muslim ban is a popular, like," he's like, "Yeah, it's a liberal thing to say," but not being it like rude towards liberals. And it made me think, you know what? I guess maybe it is a little propagandized to call it a Muslim ban. But then I explained to him why it actually was a Muslim ban, and then he kind of got it. But buzzwords.
Yeah, I mean, it is definitely a buzzword to call it a Muslim ban. I guess I could see how it's sort of a partisan sort of slogan to call it a Muslim ban. The reason why I call it a Muslim ban is because Donald Trump went to Giuliani saying, "Hey, how can we keep Muslims out of the country?" And they work together on that essentially. So I mean, it's he might call it something else, and if I'm trying to be less partisan, there may be some other term for it.
No, I mean, I would just
on that. That's fine.
I guess that is the question, or at least that's the legal question: is it a Muslim ban? Ban that for security reasons, targets countries that are almost, predominantly Muslim. So I would just say, that's what I was, but the semantics of Muslim ban is essentially assuming the truth of your premise that it is a Muslim ban.
Right.
Well,
I can get with it. I can understand. As conversations I've had in the past is essentially, if Donald Trump was capable of basically shutting his mouth and sticking to the script on this, then you could definitely present it that way. That it seemed very much like, like you said, it was, a travel ban on certain countries with, higher risk of terrorism, XYZ, and you could totally present it that way. And that's, maybe not to put, this particular cart in front of the horse. If we were going to talk about the ban first rather than Trinity Lutheran, we can't really do that. That's fine.
Yeah, no, sorry. I took us off the tracks already.
Can I explain why it's Muslim ban?
That's life in politics, man.
There's one more part of the law, though, that no one's mentioned that is why I think it's really a Muslim ban. And that is that it says if the reason you're leaving your country is because you're fleeing religious prosecution, they ask you, are you part of the religion that's the main religion of the country that you're leaving from? And it just so happens that all of the countries over there, the predominant religion is Islam. So it's saying to the Islamic adherents, you go to the back of the line, and Christians, you come to the front of the line. That's literally the animus behind the law, which has been bolstered by Trump's own public statements. And Tim, I know you have an interesting opinion on the whole concept of other law.
That's not
like they can't use his tweets against him.
Well, I think there's some factual inaccuracy there. So what you're referring to is the first executive order, which had a provision which prioritized refugee applications on the basis of religious persecution over refugee applications from those countries on some other basis. That was eliminated in the second executive order. So to the degree that we're now legally only talking about the second executive order. What's that?
Are you sure? I thought it was still the first one.
Yeah, I'm 100% positive. So for
okay, I didn't realize that.
No, and I agree with him.
The first one.
Go ahead.
In fact, if you look at the second executive order, it specifically addresses that in what is this like sub little IV somewhere. But it specifically says that even in the first one, that would have included minority Muslim sects. So, for example, a Sunni Muslim in Iran probably could have taken advantage of that minority exception to try to claim that they should deserve refugee status. But the second executive order has completely gotten rid of that in response to the Ninth Circuit's, highlighting that as problematic.
Yeah, no, I think I recall sort of those points that they had sort of cut a lot of that stuff out that was deeply problematic. But I think the reason why I think the TRO on the order was maintained or essentially reinforced as it came out again is that based on Donald Trump's own verbiage saying, oh yeah, we totally redid the Muslim ban. So now it's better and it should work this time, kind of thing. Like I'm very loosely paraphrasing what he said.
Yeah.
Basically, he came out first time saying, yeah, this is a Muslim ban. We're going to do this, that, and that, because he was following basically the rhetoric of a campaign promise. And then, that got shot all to pieces. And then, he came out and said, oh, well, this is, the new version. And it's much better. And it should, it's basically the same thing. It's just a little bit stripped down. And that's where he hung himself, essentially.
But see.
Wait, can I say something?
Go ahead.
Yeah, Dozo, go ahead.
Well, wait, can I say one thing real quick? Okay, so if it is the second band, I agree with you that because I believe all it is. Okay, so but what I'm saying is then I agree with you. It only comes down to one issue in that case because it's written much more intelligently and in avoidance of the rules. So Absolutely. Then the question becomes, what proves the animus underlying the law? And that's where they look to his own statements. And that takes in a much broader, account of what happened. Why did he really do this? And so Tim, I think your point to me, whenever you and I were debating this on the show, I mean, not on the show, on the Fermenting Opinions, best political website ever, shameless plug. But seriously, it was about you saying that there was some law that says you can't take, what was it about the Obama Act, ACA, that it was the, maybe what was it, Obama statements that it's not a tax or something? You were saying that they didn't take those.
Yeah, I was using that as an illustration of how the courts ordinarily don't really start parsing out political statements by the executive, and when they evaluate the constitutionality of a law, that it's more restricted to the face and the language of a law, and that absent facial discrimination on the basis of religious grounds, this executive order should pass scrutiny because, you know, we don't go, the court shouldn't go hunting for animus or a reason to,
unless it's discriminatory in effect. Right?
Well,
unless it's discriminatory in effect, and in this instance it is. And so, right, or am I wrong? You correct me, because I don't.
The layperson's question is this: or are we arguing, you know, disparate impact versus discriminatory intent? Is that?
That's one point I would say I'm not clear on.
Okay.
Because I didn't really that. Certainly concede completely it has a disparate impact. Absolutely. The vast majority of the people affected by this order will be Muslim.
Sure.
But what it appears, certainly none of the lower courts have talked about the difference between disparate impact and disparate effect. I was looking at the Hawaii lower court opinion applies the Lemon test, which is that's a whole nother topic. I think Lemon is
we're gonna come into that too. Yeah,
we're ready to talk to that. Let's go to Lemon.
Yeah, I love lemon law personally.
Let's transition into Lemon.
And yeah, I think we are going with that, if I may, with regards to a particular piece of legislation or what have you, having the effect of helping or harming a religion. Normally, when you see lemon law being hit on, it's because there's some law, something that's serving to advance a religion. This is the opposite end of that spectrum, where this EO is in effect hampering, you know, deliberately, essentially, or that's the argument. Go ahead.
Yeah, you're absolutely right. Normally, lemon is like, those are the 10 Commandments cases.
Right.
When can you have a religious-ish, you know, monument on public grounds or something? So the Hawaii District Court concluded that the first element of lemon, which is a secular purpose, fails. That court said that the executive order does not have a secular but has a religious purpose, finding that it has the purpose of banning Muslims from entrance into the United States. So that's how they use lemon.
Right. Yeah, and that kicks back to essentially what, as advertised, sort of the discriminatory intent on the part of, you know, Trump and Giuliani.
Is to prevent Muslims, because everyone thinks that Muslims are all equals terrorists. That's the problem.
Yeah, I mean, or, you know, there's a suspicion. You know, I don't want to label everybody who is, you know, maybe has, you know, misgivings about, you know, open borders to Muslim refugees as, you know, being having the same level of animus as, you know, the worst that's out there, you know. Sure. But yeah, I mean, essentially, if it has that effect legally, I mean, that's what seems like the issue. And yet, you know, we're sort of, as we're discussing this and teasing all of this out, it comes back to, you know, the Supreme Court said, well, no, we're gonna put sort of a stay on the TRO. We're gonna allow some of it to go into effect because it would have some sort of irreparable harm on the effect of the ban that was attempted to be implemented, to not have certain aspects of it implemented. And we're going to hear the case in the fall, sometime in the fall. I'm understanding that they're going to discuss the constitutional merits thereof. What, I mean, do you have an opinion on that?
I think in October is when they've set it for argument.
Okay. And do we know? I mean, do we anticipate? I mean, we're here. Go ahead. I'm sorry.
Conversation on mootness doctrine. which might be a convenient way for the Supreme Court to just not answer the question, but we'll see.
The mootness doctrine? I'm not sure I caught that exactly.
Yeah, I think Tim, are you on your phone right now?
Everybody just froze.
Can you hear me?
Oh,
are you on your phone, Tim?
I've got you now.
Okay. Yeah, you're coming in sort of here and there. That's okay. That's okay. Just try and work through it. Tell me about the mootness doctrine. I'm unfamiliar.
Oh, no, that's the idea that a court, if a case, well, this is a great example, potentially. It's a 90-day ban, right?
Yeah.
So if 90 days passes before the Supreme Court ever listens to the argument, it's possible that the court can say, well, this is a moot point. It's already passed, so we're not even going to hear it. I mean, that happens. I don't know. That's one way for the Supreme Court to completely avoid answering the questions. I hope they don't do that because I want an answer. But
David.
Yes.
David, to answer your it's not parochial, but what's the word for non-lawyer? But like a question, it comes down to standing. And if something is moot, then the plaintiff doesn't have standing to bring it, doesn't even have the right to bring. That's what it cuts at, is the heart of your right to bring a case. But it's one of the general theories that people use to get rid of cases, is saying you don't have standing to bring it because there's lots of things, but one instance is moot. And
right.
So moot, Tim gave a great example, which is to say that, oh, well, the only way you plaintiff have a right to recover is if you brought this, lawsuit within a period of time. Or in this instance, what he said was the Muslim ban is only going to be in effect for, however long. And once it's no longer in effect, it doesn't even matter, plaintiff, because you're not even suffering anymore. You can go do what you want to do.
Right. That was sort of, I guess, the understanding behind the maybe the official argument, in favor of the ban was saying, well, we need to take some time to, reevaluate, our refugee program, our immigration program, that we needed 90, 120 days, whatever it was, to look at all these things. That time has come and gone, and there's nothing about having a ban or not having a ban that would have prevented that sort of revision from taking place, whether or not the process was ongoing or not. It's totally have the resources to investigate those things. So I guess I could see, the mootness argument there, but it's my understanding that when the Supreme Court says they want to take a look at something, that means that there is a unresolved issue of constitutionality that they're trying to hammer out. They're saying, well, there's some vagary here, right? There's something it's not clearly decided. There's no really, definitive jurisprudence that's been hammered out on whatever this issue is, be it the ban or anything else. And they're saying, okay, we want to have a ruling on this thing that's going to set things straight for the future, essentially, so it can harken back to whatever this is when this issue arises again. And we can say, hey, well, look at the SCOTUS ruling on XYZ. The jurisprudence is pretty clear. Stare decisis. That's where stare decisis meaning. I'm not a lawyer. Saying already decided, right? That this has already been hammered out. It's already been decided. We don't need to go over it again. And that's why the Supreme Court sees cases, because there's some interesting vagaries that they want to hammer down on, essentially. In this case, a big argument is that that they don't really have standing because it's moot, because they had all the time in the world that they needed to already revise the refugee resettlement, the vetting, all that stuff. They already had time to do all of these things, and yet it's all hung on, well, we really just want to do this and ban Muslims essentially for 90 days or 120 days, whatever it is. I mean, does you guys have any thoughts on, how that's going to shape up in October?
Can I go first? I'll team up. But seriously, I think that standing is not that big of an issue. I think I think that is one avenue to easily dispose of the case. I agree on that point, but I think that it's odd that, and I used to consider myself kind of a constitutional law scholar, but I didn't realize that they could, I don't know what fancy tricks they did to request cert and the Supreme Court grants. I don't know if there was some extra thing that the Supreme Court did by granting cert to say we're going to hear this case on whether or not his travel ban is constitutional in the fall, because they let it take effect. So I don't know if it was like teed up as an injunction plus a denial. I don't know like what happened to where the Supreme Court could say, we're going to hear this appeal. And by the way, in the interim, you, Trump, can continue, basically act like the order is in effect.
Right.
So,
I mean, it's certain aspects of the order. It's like not the full order. Go ahead, Tim. You seem like you want to.
Yeah, the procedural history is, again, just looking at the second executive order issues, court in Hawaii and court in Maryland issue a temporary restraining order that then was turned into an injunction having nationwide effect, prohibiting the government from implementing any portion of the executive order. The Ninth Circuit hears the expedited appeal. The Ninth Circuit affirms the Hawaii District Court. Then the Fourth Circuit affirms the injunction from the Maryland court. Then, yeah, and I have no idea how Supreme Court, filings work, but somehow it gets to the Supreme Court on a fast basis. And so then the Supreme Court has stayed the application of the injunction, which is like a weird two negatives making a positive, right?
Right.
And so then they carved out this caveat saying, well,
but they would have had to grant the appeal. Wait, so can I like nerd out for a second? So how could they stay an injunction unless someone appealed the injunction in the first instance?
I mean, it's automatic.
The government, of course, did that. The Department of Justice.
So it's the granting of an appeal to stay an injunction.
The granting of the appeal to basically when the SCOTUS gave cert, when they said, oh, well, we need to hear this case. And they also, I guess, there's some undue harm of not staying the TRO.
Right. And so that's, yeah.
Right.
I'm looking
some irreparable harm, right? That's how they worded it.
There's always, that's like, standard for an injunction is irreparable harm.
But then to get a stay of an injunction, I think they also look at the harm on the part of the defendant saying, hey, you're hurting me with this injunction. Yeah, so it says on application for stay and petition for writ of certiorari. So I don't know. I'm not enough of a nerd. Well, maybe I'm enough of a nerd. I don't know enough to know how exactly it gets to the Supreme Court, but it got there.
Well, kudos to Donald Trump's lawyers for that.
I mean, that's basically what was done. The administration, if, whatever court they're in, if they get, they get denied the way they want it to go, they're automatically going to appeal to it. They're going to appeal to the higher court. They can continue to appeal till they appeal to the Supreme Court. Supreme Court decided to grant cert on this one. That's my understanding. And in the process of doing so, they said, well, until we've decided that it's really unconstitutional for Trump to have this EO in effect, then we're doing irreparable harm to the EO by putting the TRO out there, which is with a temporary restraining order, on that essentially travel ban / Muslim ban. So we have to let at least parts of it fly in the meantime. And that's created that's opened a whole other can of worms, because it's like some of it's in effect, some of it's not. Some of it's saying, well, you have like a bona fide relationship with someone in the United States and you can come in.
Yeah.
Not, and then the constitutional vagaries of what is bona fide, whatever.
So the second one sets out this whole list of people that have, like, you're already enrolled or you're already under contract, that kind of thing.
Right.
So I agree. That's going to be a bit of a mess, because I'm sure
ground patrol to make your
connection. What's that?
You're kind of walking out a little bit. The connection is not spectacular. That's okay. It's not a big deal. And
I wasn't probably saying anything good anyway.
No, I mean, you're giving interesting points. I mean, otherwise it's just a anti-Trump hate fest, which is, not all that fun. But but more than that, more than just being anti-Trump, I'm really interested in the legalities, that are underlying these issues and what's really going on. Because I think people have a better understanding of the law and the nuts and bolts of what's really happening. It comes.
Yeah, and if I may,
go ahead.
I think there's a definitely huge difference between asking the policy and asking the goal.
Right.
Again, I have some restraints on what I can say, but
Sure.
as a matter of policy, I'm not sure how effective this is as a policy. But in reality, I think it's perfectly legal, even if it's bad policy.
I don't want to cut him off.
And I get that. Yeah, and I don't want to cut him off either. I think that's sort of what's at hand here is is it, and again, to go back my original statement is, if Trump had been capable of keeping his mouth shut about what his intent was behind it, it probably would have been perfectly legal and constitutional. But the fact that he's sort of advertised that his intent was discriminatory, that's that he's shot himself in the foot here. And I think that's really the salient issue is how much of Donald Trump blather has served the effect of undermining his EO, and how much of that's going to come out in October when this thing's heard. That's I think is of key interest to me anyway. And Tim is totally stuck at this point. He's got a frozen screen.
Oh no.
Yeah,
I'm here. I hear you.
Okay, good.
I think you kind of undercut. If you're saying, basically everything, except for that Trump has been this thing that off the wall. To me, that kind of undercuts the legal argument against. Like what you're saying is basically constitutional and legal action. We just think the court would think that he's got bad intent, so we're going to overthrow that, which to me is really starting to get to judicial overreach, where the judges are kind of on this personal search for motives they don't like.
Okay, so I think that if I can speak real quick to that, because you and I were going on, this is why I love it when people that are on the page participate, because I remember you and I were going back and forth, Tim, about judicial. Well, was it on this?
Yeah.
Was it judicial overreach on a thread that was on Fermenting Opinions? I think it was, and it was really cool.
It was.
Yeah, and it was very well, I think, argued on both sides, or debated on both sides, and good points were made by all. But I think that, is it really, judicial overreach to me is not just taking an opinion. It's first and foremost, if the law is, it's statutory interpretation, which frankly is a Gorsuch thing. I understand you can't do it on constitutional issues, but if the text of the law is plain and unambiguous and does not lead to absurd results, you enforce it according to its terms.
So
we are having the damnedest time picking up what you're saying, and I hate.
If I turn the camera off, I think alone is.
If that gives you better bandwidth, then turn off the camera. That's fine. Because I want to hear what you have to say.
Yeah, me too.
Yeah, sorry about that. Am I a little clearer now?
You're much clearer now.
Just my stock picture of some beautiful cliffs.
Yeah, it's gorgeous. It really is. It's amazing.
Yeah, it's probably better than my face.
Those are some great cliffs. Woof. I'm getting heated.
My face isn't that great, so.
This isn't that kind of show. All right.
Yeah. So, I guess what I was saying is, what statute are you referencing when you're talking about the plain? Because the only statute I see is
That's statutory interpretation, and the reason I know that is because the area law in which I practice, we regularly rely on statutory interpretation because we're interpreting code. So, and I don't just mean as a Louisiana lawyer, but as.
What happened? Okay.
What's up?
You're fine. You're fine. My Google Plus thing opened.
So, for instance, with the bankruptcy code, that's a piece of legislation that was enacted by Congress. And every now and then, because back in 2005, it was a Republican in office, it was like a shoddy, horrible legislation that was passed. But my point is that there's a lot of parts of what ordinarily would be a very, standard type of, anyone would read it and understand what it's saying type thing. Not really, because it's stereo instructions. But my point is that the words, like, you can kind of figure out what they mean, but every now and then when you just read them according to their terms, they are ambiguous. So you have to rely on, well, shit, who's going to win this case? When I look at the law says A.
Right. And what does
B? And so at that point, then you have to look, you're supposed to look really to, well, what was the congressional intent? If a law, you can't tell what a law is supposed to mean according to its terms, then you have to try. The first thing you do after that is look, the steps are you look and see, well, what did Congress, some judges and justices have adhered to this. Others have said, no, you should never look to congressional intent. Then at that point, you just have to like try to figure it out. But that's part of like looking at congressional intent, if you ask me. But canons of statutory interpretation, I think, are paramount when it comes to ruling. And I think that in a constitutional issue, if that's a unique situation, because a constitutional issue, there's no way that when the Constitution was written, it's going to like account for everything that we're going to have to be dealing with now. But you have to take into account the fact that that's the part of like what makes the Constitution different from like, laws that are passed by the federal government or states, which change and adapt and are amended or repealed and then, amended or reinstated or written for the first goddamn time in every state. And so whenever people talk about, I think it's just, we need to be wary and be mindful of the fact that, yes, on these like hot button issues, especially when it's like constitutional issues, we're talking about judicial overreach, which again, I think judicial overreach is only really applicable when the laws are ambiguous and not when they're unambiguous and a justice says, you know what, I think the laws mean this, but I think the laws mean A, but I'm going to take I'm going to do B, versus when the judge says, ambiguous, so I think that these should be construed as whatever. And I understand and I'll be done after this, but the counter argument to that is, well, there's no way someone in like the 1850s, that's really the problem. Someone, or not even before that, whenever the Constitution, a long time before that, was passed, like did the founding, that's like originalism. Did the founding fathers, when they, wrote about the due process clause, think abortion? And conservatives would answer that question, hell no. But liberals would answer it, well, they thought about like, these general like concepts, like if they were alive now, they think this way, I mean, yeah.
Well, there's a lot of pontificating and sort of seancing of the founders and the framers of what they would have thought of, one thing or another. Those of you know me know I have some severe problems with originalism and textualism. But as it relates to this, it seems to come back to, with regards to Trump, discriminatory intent on his part that he's advertised, and whether or not that's going to present an issue for the case on a constitutional basis. And that's what I don't understand anymore of as a layperson.
So if I could start, I mean, I like, talking about statutory interpretation. So I would say, we start with the statute, which is the Immigration and Nationalization Act, that says, among other things, whenever the president, which, like it or not, that is Donald Trump, finds that the entry of any aliens or any class of aliens would be detrimental to the interests of the United States, he may, by proclamation, suspend the entry of all aliens or any class of aliens, or impose on the entry of any aliens any restrictions he may deem appropriate. So the plain meaning of that statute would say the president has the authority to say, I think these people are dangerous, or I think it's detrimental, you're not coming in. Now, obviously, though, that extremely broad grant of congressional authority isn't allowed to say, we're giving you authority to violate the Constitution, right?
Right.
So
that's
where
the question.
limit is
Side constraints there.
Yeah. So the limit is, hey, Congress, no matter what, you can't say, President, go violate the Constitution. So I think when we start with the statute, it's clear that he's got the authority to do it unless he's done it in a way that violates the Constitution. And then in reference to some of the evidence of intent behind, and this is why I don't think the court should really be going behind the law, because how do you determine what the real intent is? Because I've also, looking at the lower court, here's some evidence that they looked at. In an interview on 25 January, Mr. Trump discussed his plans to implement extreme vetting. So this would have been when he was actually president, not just a candidate. He remarked, "No, it's not the Muslim ban, but it's countries that have tremendous terror. It's countries that people are going to come in and cause us tremendous problems." In that wonderfully eloquent way that Trump talks, right? But
Right.
I mean,
Yeah, I'm surprised you used tremendous. That's 3 syllables.
yeah. So what I mean, so the court, you know, there's evidence where he said Muslim ban and then he walked it back as a candidate. So, but I don't think legally, I don't think we ever even need to look behind at all the comments of candidates, because you've got a clearly, you know, appropriate non-religious discrimination reason, which is national security concerns, which I don't think anyone can rationally second guess on. But then the Ninth Circuit engages purely in second guessing, in my opinion, which is what I think is overreach when the court, you know, courts aren't experts in national security interests. The United States elects a president under the Constitution to be the person to make those factual determinations. Then the Ninth Circuit comes in and says, well, we just don't believe you when you say it would be detrimental because, you know. So that's kind of why I say overreach, in that it's, to me, the judges are second guessing the presidential finding of what's in the national security interest of the United States.
Right. And if we were going by just his January 25th commentary on, you know, wanting to have extreme vetting and what have you, I could see that. And again, that's why I came back to sort of the original statement, is if Trump had otherwise shut his yap about what he was doing and why, then he would probably be fine constitutionally. And the issue was that there were other comments sort of before and after that have advertised that he was looking for a way to ban Muslims, and then he went to, again, and he said this publicly, he went to Giuliani asking for a way for that he can do that legally. And this is advertising intent. You know, I give this up, you know, to, you know, if we had sort of a more competent, vicious person in office, that then he would be breezing through this and there'd be no issue. But the fact that he was sort of guileless enough to betray his intentions here is what's creating issues.
But why? How is it clear what his intentions are?
Because he said he was looking for a way to do a legal Muslim ban.
Sure, but he said both, right? Like he said, as a candidate, I want to ban Muslims. Then he came and said, not really. Then as president, he said, this isn't a Muslim ban. And then he writes in his executive order that this is not about banning Muslims. So why does the court get to listen to one thing Trump says, but not also have to consider the other things he said?
Sequencing and consequences and personal benefit. And the first thing he did was say what he really thought. Then he got listened to. Then he started to say what was more convenient and more convenient and more convenient. And all of a sudden, convenience became going from being a avid anti, you know, Islam. Like Trump, if you said Muslim, he'd probably say, not because he like, seriously, that is how I think he would respond to that. Like, I don't even think he would understand the problem with responding to that like that. And maybe
sure, but that, and that's fine for you to hold that opinion.
Mm-hmm.
But as an unelected judge, you shouldn't be relying on personal, like, well, I just really don't think Trump's being honest. I personally think that he's, you know, hates Muslims. That's not enough, in my opinion, for an unelected judge. It needs to be some evidence. And again, you've got conflicting evidence, and then you've got case law that clearly says on national security issues, we accept facially bona fide actions by the president.
Okay. Okay, so great points, but I think that it is disingenuous to say that you honestly, so how could anyone honestly think that for a man who came up from his bootstraps, not from a like rich poor way, but from a like the opposite, like going from super rich billionaire to trying to like get one-on-one with the poor people, and he realizes, well, you know, I don't act, his actions don't make you think he's actually Christian in any way. His speech doesn't make you think he's Christian, or like nothing about him says that he is what he's conveying to the American people he is. Okay. History tells you that. Okay. There have been videos of him saying awful things about what he's going to do to women, to, you know, at the time. But wait, no. So history tells us everything he said about himself is not true. Okay. To me, frankly, it's a fact when I watch Trump say he's going to grab some woman by the P word. Okay. That is it. He said that. Yeah. His intent, motives, whatever. But I look at that and I say, So my point, I guess, to bring it back to reality is this. I think that to say that you are conflicted with a man who has said something that is inconsistent with something else he said in a stretch of time that is a relevant time period to look to figure out his intent on something is, generally speaking, a great way to be impartial and fair in one's assessment. However, it is not impartial and fair in one's assessment to ignore other facts about the individual upon whom you are trying to determine what they mean. And I think that it is, frankly, unintelligent for someone to take everything they know about this man and then think some of the things that people that are his supporters think. And it's frank of them to think, oh, Trump's a great guy. He means all these things. Oh, he would never say anything ever awful, but he loves Muslims. Are you fucking kidding me? I'm sorry.
You're fine.
I said this word.
We have explicit tags on everything we do in Fermenting Opinions, so it's fine. I think maybe to sort of summarize what you're trying to say is that, and what I've gleaned from this situation, and Tim, I invite you to respond here, is saying that before the EO came out, he advertised he was trying to ban Muslims, and then when the EO came out, he was like, "Oh, this is totally not a Muslim ban," and it seems overtly dishonest. And the question is, should we only take his original word? Should we only take the word of the EO? Should we weigh both? And maybe that's why we're having a Supreme Court case here, hearing about it.
Or alternatively, you do what the Supreme Court says and you don't consider any of the words. You look at the law on its face. If it doesn't have a problematic application, then you uphold it. Because the real question is, do you want the hardcore conservative federal judge, say in, I don't know, Central Alabama, saying, I don't believe Obama when he says that this executive order isn't meant to harm Christians, right? Like, you could easily have that kind of guy who's Mr. Red State hardcore conservative who then can use this and say, well, President Obama said this and this and that at a fundraiser, so I think he, doesn't like Christians, so I'm going to decide that this law, which is valid on its face, actually has an animus underneath it, and so I'm going to overthrow it. I don't think you'd like that, and so that's why I think that's why I call it judicial overreach. How about the judges just sit there and look at the statute, the executive order in this case? If it passes constitutional muster on its face, enforce it, and then let the political branches say, hey, you know what, President, you're an idiot. Stop doing that, or vice versa. Okay,
no, I can get with that if it was a fact of the matter that Obama, say, in sort of a parallel of this, had displayed some sort of animus towards Christians and then passed some sort of executive order that had the effect of discriminating against Christians, and then but then he made some statement saying he wasn't doing that. He's sort of already advertised his intent. But both of my parents, just again, for, again, not a lawyer, and I just hang around a lot of lawyers. I was sired by lawyers, but my parents are lawyers. My father's worked for the EEOC for like going on 40 years. My mom had spent at least a decade with him, and she's been with other government programs, mostly working in discrimination law. The problem is that most people who discriminate, say in employment, to create an analogy here, most people who discriminate in employment are not so guileless and stupid as to advertise the fact that they're discriminating against, Black people or Jews or people with disabilities. Yeah. They're not so dumb as to say it. And so what you look at is patterns of behavior. You look at what they call commonality and typicality of what happens to people in these situations when they're being discriminated against. Because again, most people are not so damn dumb as to say, well, I'm not going to hire someone with a disability. Actually, by the way, I work with people with disabilities, and that actually happened. And it was like a whiplash moment for me that someone was so dumb to say they weren't going to hire someone with disabilities. That actually happened. So sometimes people really are that dumb.
Some are.
And I'm trying not to go too far down a rabbit trail, but when you're looking at patterns of behavior, it's to determine intent, because most people aren't going to advertise that. And in this case with the EO, you're seeing a pattern of behavior consistent with the intent that's been advertised. And for me, it's hard to ignore that on the facts, because again, if you're trying to determine if someone's being discriminatory in a way that is, unlawful, then, you can't just look at, whether, even if he didn't advertise it, you would have to look at it, in that light. And on top of that, you've got the fact that Donald Trump has given himself away. He showed his hand essentially before the EO came out. So, and I guess that's the rub. That's for what the Supreme Court is to decide. But that's, it seems to me pretty obvious. Well, from my opinion, of course, I'm very biased and I'm very left, that it doesn't seem like overreach to say, well, you said you were trying to discriminate against Muslims and you came out with an EO that discriminates against Muslims.
Well, but
you know what I mean?
Well, but I think you kind of agree. The EO on its face doesn't discriminate against Muslims.
I think it does.
In what way?
Because what you had assented to or conceded to earlier, that it was sort of disparate impact. That
True, right.
That essentially it had the effect of going against people who are Muslim. Especially on the first one. And in the second EO, all it did was strip down some of that disparate impact from the first one, but it still had the effect of banning people from majority Muslim countries.
Yeah, I mean,
on other ways, but we already have basically all this information, in the first place. I mean, I don't know how the SCOTUS is going to go.
And so, I mean, I guess the way I kind of look at it is, I think we can all agree that it is unconstitutional to ban Muslims from entering the United States. That's clear.
Right.
So you have a candidate announcing an intent that is unconstitutional.
Sure.
And now what I'm asking you to do is to place yourself in a neutral position, which a judge should be, and suspend your personal skepticism, which I understand why you might have that.
Sure.
So the candidate announces unconstitutional idea. There's a big backlash. Presumably he has advisors once he becomes president, and all of a sudden something comes out that doesn't have that obvious unconstitutional intent. It doesn't say no Muslims may come to the United States. So why is it improper to assume that a person in government power proposes to do something that would be unconstitutional, but then the political backlash and his advisors convince him, hey, you can't do that. So then he says, okay, well, I'm not going to do that, but I'm going to do this. Why is it all of a sudden, why is that a bad thing? Isn't that what we want to have happen? Don't we want the idea that, hey, a bunch of people yelled and screamed and it got his attention, so he decided to not do the unconstitutional thing?
Yeah, except that, like, everything that his White House does evidences that they're not telling the truth about things.
But see, as a judge,
I think I get what Tim's saying here. Yeah.
And what I'm saying is, a judge is not supposed to sit there and say, I really think Trump's a liar and I think he's an idiot.
I agree.
So the only way to say he's a liar is if you're like, well, I think everything he says is a lie, you know?
Or if he publicly makes statements that his press secretary condones as being official statements of the White House.
Poor Spicy.
Well, sure. Every president tweets.
No. Whoa. What other president?
Let's not get too far off here. Let's stay on what Tim's talking about with regards to, you know, he might have said X, Y, and Z, but if the actual letter of the EO was not itself unconstitutional, will it stand? You know, I mean, and again, and it's just my opinion. I think it would be hard for the court to ignore his statements of intent with regards to what he's trying to do.
Except they said both, right? Like
how much? Yeah, how much should it be weighed? Is essentially the rub here. And I don't know.
Do you really answer? I mean, is that? Let's think about the presidential, not presidential, like the stare decisis impact. Precedential, yeah. Again, you're empowering conservative judges to go digging around the tweets of liberal politicians to upend, you know, their democratic political actions, and I don't think that's good.
But see, I honestly, because I'm trying to be consistent here, I think I'm okay with that. If you can dig up discriminatory intent on the part of liberal politician, anybody, to say, oh boy, I just really can't stand white people, or I can't stand Christian, or whatever, you know, and then they come out with some proposed law or ordinance or something like that has the effect of forwarding, you know, that animus of intent. I would say I would look to that. I would be willing to see that on the other end, and it's not, you know, a matter of, well, it's possible for me to interpret it this way. I mean, it's, you know, maybe that's a slippery slope. Is that, you know, we're talking about an overt and unambiguous expression of intent, you know, on the part of Donald Trump. If you saw a parallel, you know, somewhere on the left, I'd say call that crap out too.
Well, to be honest. And this is the parallel I brought up.
Go ahead.
Go ahead.
I'm just saying that, like, my dog made me forget, but like, look, I agree that, Tim, you're making, I agree in ordinary life, the points you're making are so accurate, but let's be freaking real. Even if not on a legal level, on a personal level, do you want a president that you're having to make these excuses for, that you're like, oh, well, he said that, but he really means something completely different, and we should just not look past the text of the law to even worry about what else he said.
But that's a subjective place. I got to go back, because I think that's a subjective standard to say, because we don't like Trump, because we think Trump's a dirtbag, we should use everything he says, you know, canon will be used against him in the court of law. Like,
I'm not saying it for anything other than to measure his veracity. And his veracity for telling truth is clearly non-existent. He's zero veracity when it comes to telling
politically, that's true. Like, so, like you were saying, David, you know, or the things you're saying, Lacey, I would expect Chuck Schumer to be saying that. Like, this guy's an idiot.
I don't even know who the fuck Chuck Schumer. The first time I even heard about Chuck Schumer was literally a month ago. I'm really not that political. The only thing that brought me into politics is mother freaking Donald Trump.
Yeah.
I really didn't care.
I guess what I'm just trying to is that there's a difference between what the political entities of our government can and should say about other political entities and what power the judiciary has when it's supposed to. Again, I guess I'm saying that the judiciary kind of has to look at an executive order issued by Donald Trump, the same as an executive order issued by Barack Obama, the same as an executive order issued by
Barack
George
Obama
W.
would not issue an executive order that says the stuff that Trump said.
Acknowledged. But I mean, I see what Tim's saying, though, is that we shouldn't treat an EO by Trump different than we treat an EO by Obama different on legal merits. And
I agree with you and Tim on that. Tim, you're right. 100%. I shouldn't have cut you off. You're right on that. I just think that we are all smarter than that. To think that Trump is sincere, come on. Who could actually think that?
I'm just saying, it's not a matter of, just Trump. I think if anybody signals intent, that shouldn't be discounted in the EO itself.
Like the girl,
again,
like
stayed at a Holiday Inn,
boyfriend,
maybe the SCOTUS, or even probably the SCOTUS will look at that differently than I do. But I'm not sure how or why the SCOTUS would discount his own acknowledgement of intent.
Because ordinarily that's what the courts do. Ordinarily they because you can see how it's a can of worms, right? Because what do you take more strength in? What a candidate, not president, says in a stump speech, or do you take what he says in an interview later clarifying it, right? You can see that's a can of worms, right? Like, how many times do politicians say stupid things? Does the court now get to go and say, well, he said this here and this there, and I'm going to believe this? To me, that's not a real smart thing for judges to do.
Yeah, okay, so, but this is, okay, Tim, how often in history has this happened?
But go ahead, Lace, I'm sorry.
How often in history has it occurred that the court has had to look at a past president's interactions to understand the intent behind an executive order?
Well, they don't, because they don't do that. This is why I
No. So is that a never? Is your answer never?
No, not never. There are cases. So,
which ones?
In this context, it's a weird, it's the case where somebody passed law that the Supreme Court overthrew, saying it was discriminating against Santeria. I think it might be a case out of Florida. That's an example of a case.
Is this the one where they sacrifice the animals?
Exactly what you're talking about. The city of Hialeah, they passed a law basically.
It was in New York. If you sacrifice animals, it's religious.
Yep.
Yeah. So that's an example where the court.
It's New York.
Where the court is saying, hey, we're going to find an animus underlying the law. So that's an example. No. That's an example where the court, I would say that's the case that gives the Ninth Circuit the greatest strength. I still think it doesn't work, but I'll concede that one does allow some ability for a court to peel back and look behind a law. But, I mean, I don't know. I think the Ninth Circuit dissent to me is the most correct. And they rely heavily on this Mandel case, which is specific in the immigration context, and basically concluded, and that was a free speech case, but that when the executive has exercised its authority to exclude aliens on the basis of a facially legitimate and bona fide reason, the courts will neither look behind the exercise of that discretion nor test it by balancing its justification against the First Amendment interests of those who seek communication with the applicant. So, I mean, to me, that's the court saying, hey, this national security thing, immigration, that's purely political. That's Congress. That's the president. And if it's valid on its face, we're not going to open the can of worms of looking for animus. Because I think Hialeah, sorry, I'm taking a little while on this comment.
You're fine.
I think Hialeah was basically a law where the city basically...
They were sacrificing animals.
Right, and the city picked...
It was Sharia law, essentially. It was Sharia law.
Santeria, which is voodoo out of Haiti.
No, it was Sharia law, essentially.
I understand the allegory you're making there. But yeah, the Santeria thing, I mean, it was because in their sort of arguments, the first time when they tried to pass it, and there's an interesting parallel here, is saying that, oh, Santeria is nasty, we don't like it, so we're going to pass this law saying you can't do this within, city limits or whatever, and they lost on a constitutional challenge that it was discriminating against the free exercise clause, right?
Yeah.
Saying,
so like, to me, I would, a good analogy of Hialeah would be, let's say Trump made an executive order saying you can't wear a hijab or burqa in federal buildings.
Right.
To me, I would say that does not pass that, even though on its face is valid. It's so narrowly targeted at a religious act
Right.
That's why it fails scrutiny. Whereas which is why I think Mandela is a stronger analogy, because in the immigration context, this is not an EO that's narrowly tailored. Well, in my opinion, it's not like it's narrowly targeted at Islamic people. It's targeted at 6 countries that are failed states and have no way to give us assurance of security normally associated with immigration processing.
Right, and I think the problem with that is the revision between the first and the second EO. The first being that it gave there was language in there that gave preference to religious minorities in those areas, which was a clear nod to Christians, which again Donald Trump advertised as part
why
of
isn't it? Yeah, why isn't it a nod to, say, Sunni Muslims in a Shia majority country?
It could have been, but Donald Trump said it was a nod to Christians.
Yeah. I mean, yeah.
That's after when it was put out. He basically said, that he felt bad for the Christians in his area. Essentially, if someone please look up and correct me if I'm I am paraphrasing, but
no, that is correct. Although religious persecution has been grounds for refugee status for a long time.
Sure, but if we're talking about this specific targeting, saying we're going to specifically target Christians for preference coming from these countries, which the obvious conclusion therefore is that is to exclude or to put at the bottom of the list anybody who is not a Christian or not other minority religion. I think Breitbart put out some articles about other minority religions in that area to try and sort of deflect a little bit from that. But it was about giving preference to Christians versus the Muslims in that area, that you were going to go to the bottom of whatever list or just really not have any good chance at all. And one of the reasons it was struck down was because of that provision. And basically rewrote it. And then he made a further mistake. I'm sorry, let me finish. He made a further mistake by saying, it's basically the same thing as the first one, which comes with a lot of baggage. And maybe that's one of the things that needs to get hammered out in the case, is saying, it's basically the same thing as the first one, except just a little bit stripped down. Well, does that mean it had all the same intent behind it? Certainly sounds like it. And that's why it was struck down by the lower courts. But, of course, now we have this appeal.
So I actually probably need to get back to work in 20 minutes, and I don't want to not talk about the Trinity Lutheran case.
Yeah, okay. Do you want to wrap up?
Yeah, that's a huge one.
My final thoughts on the immigration thing is just that I think it's the Ninth Circuit and the Fourth Circuit are second-guessing the president's political discretion on national security. I think the Supreme Court will uphold it, and I don't think it's going to be a 5-4 decision. And I'll just throw out a bombshell. Maybe you guys can talk
after
if you guys are going on. I think Ginsburg, does she have to recuse herself? I don't know.
Who, Ginsburg?
Because she said how much she doesn't like Trump beforehand. Yeah.
Oh my God! Only if Trump has to be bound by his prior statements. That's
my bombshell.
Yes.
No, that's my point. If Trump is
bombshell, thank you.
If Trump is bound by, if Trump is
no
bound
motherfucking way.
If Trump is bound by his interview statements, shouldn't Justice Ginsburg be bound by hers?
Then he's impeached. She's recused. We're all fucked because we have Pence as a president.
Yeah. That's my bombshell.
Tim, that was amazing. Thank you.
Yeah.
Konnichiwa.
So yeah. Anyways, the Trinity Lutheran case.
Yeah,
I would like to talk
quickly,
a little bit. You guys can continue after I leave, but I've got about 20 minutes.
Yay!
Great. So yeah. Okay. So Trinity Lutheran. The case, as I understand, this was out of Missouri. Trinity Lutheran applied for, I guess, some state grant money to relay their playground area with like tire clippings or something like that. Like there was money allocated within the state for people to apply to have this thing happen basically on sort of these playground type areas. And they were denied. And this is like in 2012 or 2014 or something like that at this point. You say, well, no, you're a church. We can't apply, government funding, public, which is, comes from tax dollars, tax funding to support, a religious institution. So you can't do it. And so this was appealed to the Supreme Court. The Supreme Court heard the case, and to me, which is beyond baffling, that it went 7-2 in the Supreme Court. That it didn't even get all the liberal judges saying, no, you can't do this because it's a clear violation of church and state separation, which I am a huge proponent of. I'm actually the vice president of my state's chapter of Americans United for Separation of Church and State. So to me, I'm completely lost on this one because I don't understand how this flies. I don't understand how it passes the Lemon test. I don't understand because how it doesn't ignore jurisprudence that's already been established, because there have been cases in Boston of a historic church in Boston that needed like as a windows replaced or something like that after a storm, and they said no because we can't apply public funds to. And I wish I had the specific case to cite to you guys, but
what are the rules about, like, for instance?
But go ahead. I'm sorry, Lace.
Well, no, David, I'm sorry to even cut you off because you just sounded like way more educated about it than I did. But what happened with the cases, for instance, to piggyback off of what you just said, like could public funding go to pay for school books in Catholic schools?
Right. I mean, that's where Lemon Law came from, right? Is that,
Let's start there.
Kurtzman, in was 73, I can't remember. Basically, with regards to whether or not these public funds can be applied to, a religious institution for even something that seems, inoffensive, essentially, with regards to, its purpose. And that's where they established that there should be this Lemon test, of which there's 3 prongs. So one is being whether or not a law, it sort of forwards or hinders a religion or its impression, I guess, upon people, whether or not a law has a clear secular purpose, and whether or not it constitutes an unnecessary entanglement with religion. And in this case, if government money, public tax dollars are going towards a religious institution, I think there's at least two prongs of that test, being entanglement and endorsement of religion, of which it's failing. And there is also an endorsement test, but that kind of falls under Lemon Law too. And that was Sandra Day O'Connor thing, I think, in the 80s, that there's a religious endorsement test as well. And that if money's going to forward essentially the mission and the presence of a church in the community, that seems like, to me, pretty, overtly assisting a religion in its mission. So I don't know how it went 7-2. I can only hope that it's not just, really, I don't know. I don't know why it went another way. And if someone can explain it to me, I can maybe gain some insight here.
And what do you think about the Trinity Lutheran Church case?
So,
since you're a limited amount
and I am not an expert on First Amendment law. So, because I'm trying to search my brain and when Lemon gets used, because the Supreme Court doesn't talk about Lemon at all, and I don't think the dissent does either on this one. So, some reason they're not thinking Lemon applies, and I can't remember why. And then I'll admit, I'm just looking at the SCOTUS blog. They have an article about the potential application of this case to school vouchers, and I guess there's a Zellman case where they upheld school vouchers.
Zellman, I remember that one. Yeah, I took a First Amendment course a long time ago.
So I probably have a fairly radical view of the First Amendment, which maybe I should educate myself out of, maybe. But
okay.
And I'm probably more in a Clarence. I think probably a Clarence Thomas. We'll see where.
So you like to
That's pretty radical, yeah. But go ahead.
Clarence Thomas level in that. So I think Lemon is crap. I think it should be exploded and gone away. I think it's, that's another discussion. So I think a relatively anti-religious view of the First Amendment has created a friction between the establishment and the free exercise clause that keeps causing all these problems, right? And so, I mean, this case is a clear example where I never heard this phrase, I guess, so play in the joints between the two clauses.
How have you not heard of play in the joints? That's like,
I don't know, because I'm not an expert on religious freedom, so I plead a lot of ignorance. I think the my most neutral approach to this is it boils down to how you look at the question. If you read, was it Sotomayor's dissent? I think she's the dissenter.
Yeah.
Sonia Sotomayor.
So she, yeah, and I'm surprised as well that Kagan was with the majority.
Yeah, that kind of baffled me. How many?
That's one of the things we wanted to check with you is what were the final counts, because there were a lot of concurrences.
It's Ginsburg and Sotomayor.
Yeah.
Are dissenting, and then the concurrence is, I think, Gorsuch and
Brennan.
Gorsuch and Thomas and maybe Alito.
Well, no, but Rob. No, I thought that
there's concurrence, and then there's people who were sort of siding.
Roberts delivered the opinion of the court, and then who are the three? The three Gorsuch writes for a concurrence that takes probably a view of the First Amendment that I like more, which is even more. Yeah, so Gorsuch and Thomas are the ones that said they would have taken it even further. And then Sotomayor and Ginsburg dissented. But so Sotomayor frames the question as saying that the court is ruling that now government has to provide money to religious entities. I think that kind of misses the point, which the real question in my mind is, it's not saying that you have to make funds available per se. What it's saying is, if you make funds available on a neutral, non-religious, all-comers welcome program, you may not purposefully exclude religious entities from the benefit of those public funds. And to me, I'm okay with that. Like, yeah, if the state's going to come up with a program, you shouldn't be at a disadvantage because you happen to be a religious entity.
Yeah, it should be based on merit. I completely agree. But if it's not a merit-based test, if it is a whether or not we think you're worthy test, I think that the intent of the decision maker on who is worthy or not should be taken into account. And when it's the government, if the decision maker happens to be a particular religious group, then they can't be. And I think that means we should they cannot be prejudiced toward a certain religious group. And I think that it's the same way. I realize this only now that I've been offended whenever I used to belong to another group online page called like Whiskey and Politics. And it was like on there, I felt like if you didn't feel a certain way, they would judge you. And I don't want to be like that, but I just think that,
well, I guess, no, in this case, the state of Missouri said, hey, if you are a child care center and you want to upgrade your playground to rubber surface, somebody's at my door randomly. Oh, sorry, I apologize. Someone's coming to my apartment. So anyways, long story short, right, Missouri says, hey, if you want money to resurface your playground, come apply. And then they select people on the basis of like surrounding poverty, et cetera, et cetera. But they said, if you are a religious entity, you may not even apply for this money.
Right. And that comes back to the issue of being lemon law, though. That
so the court,
your secular purpose in resurfacing a playground, if you are a church, can you say there's a clear secular purpose? I think that's extremely hazy at best in the most positive light, saying that why as a church do you have a playground? Do you just care about kids having a place to play? Can you really separate that from wanting this to be a center where you're drawing people in, knowing that it's a church and knowing the intent and purpose of a church and knowing the church's mission? Can you actually separate those two things? I don't think you can, and I think that's why lemon law exists.
Yeah, I do take this as the court backing away a little bit and becoming a little more permissive. I think it is a change. It's not just like a but I mean, so to me, because then the other side is why does the government get to say if you're a church you may not participate? Because how is that not prohibiting? How is that not religious discrimination?
Well, I mean, is it? I would say it's not necessarily not discrimination against religion, but there's a constitutional purpose in doing so. It's like, any law that's created is sort of going to cut against, there's a purpose, that some people are allowed to participate in whatever program, system, situation, and some people are not. There's criteria that's involved there.
Right.
You could say, and I've had this argument with somebody that they viewed death certificates as discriminatory against alive people because you have to be dead to get a death certificate. And isn't that unfair, right? That's the absurd, extreme of this, right?
Yeah.
Can I say something?
Go ahead.
Y'all know it's going to be leftist, but for real, I just read this article that is about how do I have to explain to people to care about others, and it was about the healthcare bill, which I know is completely different than what we are arguing about right now. But I kind of see the transcendence of it from health and life or death into just our conversations with one another. It's still life or death. Sometimes things transcend politics. And I just think that right now, everything in America is so politicized, and
Sorry, go ahead.
It's terrifying to me because it's creating a war.
Oh, either way, it's gonna fuel divisions. A decision like this, that it's either, oh, we'll look at government endorsing religion, or it's, oh, these poor religious people are being persecuted. And in either case, the outcome, I think, is going to be negative for society.
So, for example, I would.
Go ahead.
Why this? Let's say you had. I don't know if this is a such thing, but I suspect there are. Let's say you have a mosque associated with an Islamic hospital, there's Baptist hospitals, Catholic hospitals. Should they not be able to come and ask for government grants that are available to all other hospitals, for certain types of medical stuff? I think that's why this case is, you see it going 7-2, is because it was to me, the rule from this case is if you have established purely non-religious programs of common application, the court is saying churches have to be allowed to play as well.
Right. And
that's scary to people.
If that were the case, I probably would see it that way as well. But I guess one of the differences in between, a church playground and, a hospital that's been, funded by, a particular religious, moniker, that it's the Baptist hospital of this or the Methodist hospital that, or the Muslim hospital of, XYZ, that, in those cases, those pass the limit test because there's a clear secular purpose, that it's not ennobling or hindering anybody's religion. And there's no, overt entanglement that these monies are going towards just hospital stuff, and they're not really helping or hurting anybody's religion. In this case of the playground, that it's clearly certain because it's on church grounds, that it's
right.
Clearly to promote the mission of that particular church or parish or whatever you want to call it. And so to me that violates, those prongs of the lemon test, where is with a church, it wouldn't be the case.
And
go ahead.
Yeah. So I don't like lemon because I think lemon is saying that the First Amendment requires the government to be anti-religion as to be almost against religion, as opposed to just saying, hey, we just sit here and we don't pick and choose between religion. To me,
I appreciate. I like that. I like that. Keep going.
I'm just saying, I view the First Amendment more as, hey, the government has no business picking and choosing between religion, but doesn't require the government to say religion is bad, and the government can't ever be, holding hands with people, entities that happen to be religious in their mission, as long as it's on the same ground that non-religious entities.
Right.
But that's why I say I'm a little extreme, because I would get rid of lemon. So
yeah,
I like Clarence Thomas-ish.
Right. Yeah. Thomas and Scalia in his day, and Gorsuch has spoken out against lemon test as well.
Yeah.
And that's to me, extremely disturbing as someone who's interested in religious liberty, because I think there's a characterization behind some of the misgivings in sort of lemon law rulings that it's sort of it's showing like a hostility towards religion, and I don't think that's really the case, or that's not the intent as I see it, or as I'm trying to encourage anyway in other people, of saying let's not give preference to anybody who if like you were saying, if someone was trying to apply for something for the same reason as everybody else, I wouldn't have a problem with that. But it's not I don't see it as the case in these situations. That it comes to who's basically got their hand up first of saying, hey, put me at the front of the line kind of thing, and just happen to also be a religious organization. And I think if we're to live in a secular under a secular government where everybody's religious freedom is enforced essentially, and that it's pluralistic and there's room for all or none religions to flourish, that has to be strictly maintained. And so the government cannot give appearance to giving preference to anybody's religion, or even give the appearance to harming to anyone's religion, because I think that absolutely has a chilling effect.
Yeah, but should they give preference to the non-religious?
No.
No, I think
but it's not on the grounds of being non-religious.
Why should
it's on the grounds of not commenting on. That's the difference between. I think a lot of people view secularism as being anti-religion. Secular is basically saying no comment on the topic of religion. That's what it really means.
But this case illustrates how that does become anti-religion, because why, in my opinion,
sure,
why should ABC for-profit child care center, not associated with the church, get government money, but Trinity Lutheran shouldn't get government money just because they happen to be a religious entity?
Can I answer this one?
Go ahead.
Can I answer it? Because, Tim, this is about a playground. The playground got the money. If I was a non-Christian and I walked on that playground, what do you think every child and every parent would have wanted to do with me as soon as I walked on that playground? And by every child and every parent, I mean anyone that's of age and able to understand the importance of proselytizing.
Yeah, proselytization. Yeah. And I think the court even recognizes that religious entity does engage in proselytization.
So do you then believe that it's true that not true, but as a matter of law, do you think that if the purpose of that playground is to be able to find candidates you can proselytize to and convert, as someone who's an atheist, convert to your religion, do you think it is able to get the same government funds as any other privately owned institution?
Yeah, to me, as long as the theoretical atheist daycare center next door is allowed to apply for the same money and then, try to convince kids against
daycare center next door is able to. I agree.
I think government money should be
equally distributed. I agree.
To the religious, the non-religious, and the atheist entities on exactly the same way.
100% agree with that.
But yeah, so that's just my opinion on that.
100% agree to the extent that there's no overreach, such that in any one geographical place, there's a influx of rich people that are a religion and poor people that are something else. Because I don't think that you should, as a poor person, not have any say in matters that are personal and biological or whatever to yourself. So I think that I'm very sensitive of religion getting entwined with,
Right, and I think that's why it's important to separate, my personal opinion as an atheist, what my personal opinion on one religion versus another is, and looking at what is actually fair in a pluralistic society, as I believe and understand to be enforced by the Constitution, and that's what the free exercise and establishment clauses are about, and that's why I think lemon law is a good way to enforce the establishment clause, which is to say that we should not be helping or harming anybody's religion, essentially. And if we're giving government money to forward someone's religion, be it trying to proselytize Christianity or proselytize atheism is not a religion, but I could see where it might strike on that same kind of chord of forwarding an opinion on religion. Even I'll go
right.
that one or the other should not be ennobled, and refusing to ennoble Christianity being the majority religion is not the same thing as ennobling atheism, because secularism and atheism are not the same thing.
No, but the rule at issue in this case is churches need not apply. Go to the back of the bus if you're a church.
Well, no, it's churches need not apply because the government cannot endorse religion.
But I mean, that's what I'm saying. The rule literally was churches may not apply for this grant for their playgrounds.
Right. I mean, and I don't, that may feel unfair to a church, but I don't see that as a constitutional problem or a problem of general.
Well, yeah, because it's the only grounds for them getting worse treatment than the others is that they happen to be a religious group. And so how is that not essentially establishing non-religion above religion? And so how is that not prohibiting their free exercise? Discriminating on the basis of religion.
Not being able to access additional funds doesn't affect their free exercise. I guess. At least
well, but what if it does? What if you said a mosque may not apply for this grant? Then clearly you're discriminating against a religion by saying
but we don't say that. We say we don't. But that's not what the law says. The law says there shall be no establishment by the government of a religion. And so by giving one religion funds, it is a exclusion of other religions. So if you're going to give all religions,
it's not even one. It's any religion. If it's Zoroastrianism, is applying for. It doesn't matter who it is. It says in all cases we're not going to give money to religion because it's a violation of a citizen's freedom of conscience.
Yeah. So, I mean, I unfortunately do need to go back to
work. Right.
But that's just my...
I would love to continue
I acknowledge I have a somewhat extreme-ish... I don't think it's extreme, but it certainly would be asking to change court precedent on the First Amendment.
Sure.
So with that, I've really appreciated chatting. I hope you guys have an awesome rest of your evening. And cool. I'm going to go spend your tax money. And thank you for paying your taxes because it's my salary.
Absolutely, and thank you for your service and your involvement.
Now it sounds like I was trolling for that. No, I'm saying thank you for paying taxes so I get to go live here in Japan.
No, but thank you for participating in us, Tim Keen, so that we can not get paid to do what we love.
Maybe one day we're gonna get famous, guys. All of us.
Yeah, this is awesome.
Rising tide raises all ships.
Thanks for being a member of the page, Tim. We love you.
Yeah, love you guys. And
really
have a good one.
Really enjoyed your participation here. I really liked your input. Thank you for coming on. We want to have you definitely.
David Lacey, good to meet you.
You as well. You take care.
All right,
okay.
All right. Y'all have a good one.
All right. Be good. And Tim has left us. Okay. No, I think it's been a really good discussion. I like the pushback. I think this is, to me, again, being a big advocate of secularism, a big advocate of church-state separation, it's important to understand the nuance here that, and I am not going to go anywhere near trying to declare victory in his absence or anything like that, or badmouth anything he has to say. But I think it's really important to understand that saying we're not going to ennoble religion is not the same thing as saying we're going to ennoble anti-religion or atheism or anything like that. And that's an important thing to understand nuance about. And that's where the groundwork has to happen. And he has, like he said, an opinion on lemon law and the First Amendment that goes very much against precedent. And I think there's good reason why it goes against precedent. but those are continuing conversations I want to have with him, because he's an intelligent guy. He was knowledgeable. I enjoyed talking to him and having him on. I really hope we can continue this conversation.
Yeah, completely agree. He's amazing. And I think that he was very intelligent and well prepared for a wonderful conversation.
Absolutely.
And I think that he was able to open my mind even further to an opposing view. So thanks to him for that. I also thank you, David, for such an incredible opportunity to continue to think the same way that I do. And I think that you're absolutely right. Tonight was just such a great night to sort of explore the brain of someone who is just, intelligent, yet at the same time thinks of thoughts that you and I both don't. Sure. And I think, exchanging the depths of each other's minds are going to be mutually beneficial. So,
yeah, part of what Fermenting Opinions is about, and that's sort of our tagline, is that we're in search of a more palatable political ferment, that we want to find people that we disagree with, and we can talk to them like human beings and not some kind of evil caricature that's subhuman or something like that. Like, he's a real guy. He's sincere. He's intelligent. He disagrees. We have strong disagreements on things, but I feel like we got along well despite that. That's what this is about, is trying to come to a greater understanding, continue to come back to the table, and find places where we can agree on, as well as places where we can, understand why we disagree, without attributing some nefarious motive or some moral turpitude on the part of the person that we're not agreeing with. And I think tonight was a great example of that. It was a nice, intimate conversation. It was like three of us. There wasn't a lot of talking over each other. It was fun. I enjoyed it. There's so many things going on right now. So many things that we're going to continue to talk about in regards to the healthcare bill that was delayed, because, McConnell.
I'm waiting for that throwdown.
And it's still going to happen because James and Siobhan need to have a knockdown drag out about it. If James can find the time, but he was working tonight. In his defense, he was actually working tonight.
It's hard to do what he does, man. It's hard to do it like you. We are all adults. We're all like past 30. So like once you like hit 30, you're just like, oh shit, I'm busy.
I'm gonna be 36 in a couple of weeks. But anyway, I think this is a good note to end on. I had a really good time. I enjoyed the conversation. I hope people like this. Please come subscribe to the YouTube channel. Come check us out on fermentingopinions.com. Come see us on Fermenting Opinions on Facebook. There's a public page where I post as many of these as possible, as well as the itself, where we find amazing, intelligent people like Tim.
Like Tim, yeah, I know. Yeah, so I really if you want to come chat with us, we'd love to hear you.
Yeah, absolutely. We give some respectful pushback, but emphasis on the respectful. And that's what we're about. And with that said, I think y'all have a have a lovely evening and good night. And you've been a wonderful audience, all of who's watched this except us. But hopefully some people will check it out. Till next time, I'm David Papiden, and this is Lace. Hold up.